Thank you, Mr. Chairman, distinguished panel members, ladies and gentlemen. Thank you for attending our panel session. I want to thank the organizers for inviting me to speak here, and again, thank you for your kind attention to my remarks. A lot of what I'm going to say will overlap with some of the things Mr. Daniels said. I believe I'm speaking from a slightly different perspective, and therefore I think it will help overall understanding. Let's see. Nope, this way. Okay. I'm going to provide an overview. As Mr. Daniels said, the rules for challenging U.S. patents changed substantially with the AIA, and the bulk of that went into effect last September. And while Mr. Daniels was talking about the procedures that were available, generally available before September 16th of last year, I'll be talking about the procedures that have been available since then. But there's, again, a lot of overlap, and we'll see this. But one of the things that resulted from the AIA was to provide a significant increase in the number of alternative ways one can challenge a granted patent. Since the AIA, the U.S. has 4 alternative procedures. What I'd like to do today is to talk a little bit about why we have multiple procedures, then go through an overview of each of the procedures for you so you can see what the different procedures available are, and then talk a little bit about the estimated costs and the strategic considerations for picking one of the 4 possibilities. Post-grant challenges to patent validity. Typically, traditionally, you can assert in court, an infringer can assert invalidity as a defense to a patent infringement charge. That's part of a larger, very complex litigation. However, there are also some possibilities, and the AIA instituted a number of these, for specifically pursuing challenge to the patent. There's a possibility of having the patent adjudicated invalid in court. There are also a number of procedures where the patent can be judged invalid or significantly limited, as Mr. Daniels described, in a proceeding before an administrative agency that doesn't actually get to court. The reasons that the AIA included new ways of challenging patents were, in at least a couple of the reasons that was included, were the concept that there are a fair number of patents that should not have been granted, that are invalid in fact, even though the examiner didn't realize it. And some of these procedures were added as a way to simplify the possibility of getting these invalid patents off the books. Another major issue that was considered when the legislation was under discussion for the AIA was to provide a lower cost alternative to patent litigation, if at all possible. To the extent that these things have been successful, there was concern that potential infringers would exploit some of these new procedures to harass patent owners. And so there are ways of limiting that problem. One of them is to limit the grounds for challenge, as Mr. Daniels indicated. The grounds for challenging in an ex parte reexamination or an InterParties review are only prior art. You can't challenge on grounds of lack of enablement or improper, unpatentable subject matter. So the patentee is protected from those kinds of challenges when limitations on the grounds are part of the statute. Another way to limit the patentee's exposure is to limit the time period for challenge. Most countries have a very limited time during which you can file oppositions. Some are 3 months, some are 6, some are 9. But that means that once that period is passed, the patentee no longer has to worry about repeated challenges interfering with him doing the rest of his business. Another way that challenges can be limited is to stop the challenger from filing repeated challenges. Once a decision has been made, the challenger is precluded from challenging that patent again. The AIA picked and chose among these options for different procedures. Historically, we have had ways of challenging patents going back to the very beginning. At the earliest part of the U.S. patent law, invalidity was a defense available during lawsuit. However, the administrative procedures, some of these variations, are more recent. Reexamination only became available with a statute that was passed in 1981. InterParties reexamination was an attempt to increase the alternatives a little bit, and that in part is a reaction to what happened with the ex parte reexam and the fact that that took off fairly slowly as a procedure. In 1999, InterParties reexam became part of the U.S. law. That was revised in 2002 to make it hopefully with the thought that it would make it more attractive as a venue for challenge. I will also include the institution of the Central Reexamination Unit in 2005 as part of the acceleration of administrative challenges. As a result of moving reexamination into the Central Reexam Unit, the degree of success by challengers went up substantially. And that made the whole process more attractive. And then, of course, the AIA instituted a number of revisions beginning in 2011 when the law was passed, and the major change in 2012. There's a little bit of it that's still not going to come into effect until March of 2013. The list of the procedures that are available, ex parte reexam was discussed earlier, PostGrant review, which I'll talk about in a minute, InterParties review, which again Mr. Daniels discussed briefly, and declaratory judgment suit. The last one occurs in a district court litigation. The first three are administrative procedures that are held within the patent office. And there are reasons why one or another of them may be particularly more beneficial under particular fact patterns. And hopefully we can talk a little bit about that as we go forward. Within the administrative procedures in the patent office, the post-grant challenge occurs in 2 phases. There's an initial petition phase, which is the only phase where the requester, the challenger, participates in an ex parte reexam. This is when there's a filing of a request for challenge. The patent office then considers that filing and decides whether the threshold has been met. If so, they will institute an examination phase, and each of the different procedures has slight variations within these, but they all fit within this overall framework. I'm not going to say very much about ex parte reexamination, since Mr. Daniels, I think, did a wonderful job of describing all of that. One thing I will mention is, as he pointed out, the Central Reexamination Unit is responsible for ex parte reexamination and will continue to be going forward. I agree. The examiners on the Central Reexamination Unit tend to be, I think, the smartest examiners that I've ever encountered. On the other hand, compared to examiners in normal ex parte examination, the normal examination examiners work in the same art. They have a fairly narrow scope of inventions that they consider, and they're very familiar, most of them, with the relevant prior art. There are a few specific things that are discussed with regard to the particular invention, the particular application they're looking at, but their general familiarity with the art in that subject matter is routinely pretty high. In contrast, while the central examiners are very intelligent and are very highly trained technically, they are not at all familiar with the subject matter of the patent. And therefore, the original request and all of the submissions going forward need to have a lot more background information. And I think a lot of us had difficulty when we were initially doing reexaminations because we tended to file briefs that were a lot more spare, that had a lot less information in them, and would get, despite the quality of the examiners, would get some very odd initial reactions because simply the examiners really didn't understand the things that we hadn't bothered to mention because we thought everybody knew them. Again, with a two-stage procedure, the petition phase determines whether there is a substantial new question of patentability, and there's some participation at this stage by both the requester and the patentee. Examination is before a panel of 3 examiners rather than a single examiner, and participation is only by the patentee and can be both written and oral. One of the consequences of that is I have found ex parte re-exam is a quite reasonable approach for novelty challenges. If you have something that the reference clearly anticipates some of the claims in the patent, they usually get that right. Where you're looking at an obviousness challenge, it's a little more problematic because the patentee will have a chance to sit down with the examiner and discuss the various concepts that may or may not be obvious, whereas a challenger is precluded from taking part in that part of the operation. So the type of challenge one can make to a particular patent is one of the criteria that you ultimately consider in choosing among these procedures. Simple looking at the procedures, ex parte re-examination can be filed anytime after grant. You don't have to wait for a specific period as some of the other procedures. It's a relatively low-cost procedure. It has no estoppel attached to it other than the simple res judicata of whatever's decided is decided and available for presenting to courts later, but there's nothing to stop you from making the same argument that lost in an ex parte re-exam to repeat that argument in a different forum in an infringement suit. Post-grant review is the first of the new procedures with the AIA. I think our Congress, when they passed the law, were thinking of something similar to the opposition procedures in the European Patent Office, which are fairly free-form procedures that have a lot of give and take back and forth. The USPTO, when they were asked to set up rules for the process, chose something they knew about, which is interference procedure, which is a much more structured process, and as a result, the U.S. post-grant challenges are nothing whatever like a European opposition. They're probably closer to, say, a Japanese opposition or Korean opposition, where the structures are much more formal. Having had some experience with InterParties review InterParties Reexam, which can run for 4, 5, 6 years. The Congress attempted to make post-grant review a fairly quick procedure. They put a 1-year limit on the length of the procedure. When the USPTO formulated rules, they limited the 1-year effect of the statute to only the examination phase. The petition phase is outside the 1 year. So you really are dealing with typically a year and a half or a little bit more for this type of review. And you have full participation by both parties. In fact, I think you actually see a higher level of participation by the challenger in the post-grant review and in the inter-parties review that I'll mention shortly than was possible in inter-parties re-exam. Again, it's a 2-stage procedure. The threshold is the threshold that Mr. Daniels mentioned of, and I paraphrase it, he gave you the actual statute language. I'll paraphrase it as at least one challenged claim appears to be unpatentable. Post-grant review allows any grounds of invalidity that would be available in litigation. So post-grant review in the Patent Office can challenge for lack of patentable subject matter, for lack of enablement, for lack of clarity in the claims. These things have to be put together in a petition that the Patent Office ultimately agrees seems to indicate at least one claim is unpatentable. Evidence during the petition phase is submitted by declaration, and there is participation by both parties. The patent owner can argue against instituting a review. Then the Patent Office decides, if they decide to proceed with examination, it proceeds before a panel of 3 administrative patent judges, a level above the level of the examiners in the CRU. Under the procedure that's been instituted by the Patent Office, there is a limited opportunity to amend claims. Essentially, you have one opportunity, the patentee has one opportunity to amend claims. While there's the potential for further requests for permission to amend claims, the position the Patent Office has taken is we intend to deny all of those petitions. There's a single oral hearing which is conducted on briefs. As Mr. Daniels mentioned, there is some discovery in these procedures. Basically depositions, typically depositions of the inventors, depositions of anyone who's submitted a declaration during the initial phases, during the petition phase. This is substantially fewer depositions than, much less discovery than would happen, say, in a litigation, in a district court litigation. And the ultimate decision will be issued after the, sometime after the oral hearing. It's promised by the Patent Office that the written decision will be provided 1 year within 1 year of the original declaration of the examination at the end of the petition phase. Either party can appeal. This is in contrast to the ex parte system where appeals are only allowed by the patent owner. Either party can appeal an adverse decision to the Court of Appeals for the Federal Circuit. Things to consider in deciding whether to institute a post-grant review. Probably the key one is the estoppel. One is estopped from raising, in a subsequent proceeding, say an infringement litigation, the challenger is estopped from raising any issue that could have been raised during the post-grant review. And as I said earlier, one can challenge in a post-grant review for any ground that could also be used as a defense in litigation. So in effect, if you file a post-grant review, you will be precluded from challenging the validity of the patent in district court litigation. That's going to be argued, I'm sure, as we go forward with these procedures, but at the moment it looks like one should assume that if you file a post-grant review, that's your attempt to challenge validity. Although if the parties settle, and settlement is encouraged by the statute, if the parties settle prior to the oral hearing, the settlement voids any estoppel. So that's part of the incentive, I think, to encourage settlement. As I said, discovery is limited. A consequence of that is that the costs are much lower than they would be for a full-blown litigation, although the costs are substantially higher than most procedures that one sees in the patent office. As Mr. Daniels mentioned, the tribunal here, the administrative patent judges are familiar with patent law, they're familiar with technology, two things that you can't count on in district court. The last point to point out with the post-grant review is that the request must be filed within 9 months of the grant of the patent. After the 9 months have passed, one is precluded from filing a post-grant review. In fact, after 9 months have passed, you can file an InterParties review, which is essentially the same sort of procedure. All of the procedural rules are nearly identical, but the grounds for challenge are limited to only published prior art, patents and printed publications. Again, it has full participation by both the requester and the patentee. I'm not going to spend much time here because this is essentially identical to the slide for post-grant review. Selection criteria, again, are essentially identical to the ones that we just talked about for post-grant review, with the exception of the last line, and that is that the request must, if there is an infringement suit involved, and many of these procedures, as with many of the InterParties reexaminations, were associated with an ongoing infringement suit. If there's an infringement suit filed, the defendant has 1 year during which they can file an InterParties review. After that 1 year has passed, they're precluded from going to the patent office. They have to do all of their validity challenge in court as a defense to the infringement suit. Which leads me to sort of the I think we have questions at the end.
I just wanted to interject one time. There's a serious drawback to these proceedings in that there's a page limit constraint.
Yes.
There's an estoppel associated with it, and I think that's a very important aspect of both of these proceedings.
Yes, I will agree with that. The last way that the U.S. allows challengers to attack a patent is in court with a declaratory judgment suit. This, again, can be filed anytime after grant, can be filed on any grounds of invalidity, as well as non-infringement. However, a declaratory judgment suit frequently triggers a counterclaim for infringement, which means that you're essentially invoking a full-blown infringement suit. I think I'm probably not going to spend much time here. Because this is a full-blown litigation procedure, the possibility of resolving all of the issues between the parties is there, which, of course, is not present if you're only challenging validity in a patent office proceeding. But that also means that you have all of the full range of discovery on all issues, and the costs go way, way up. Okay. Let me move on to sort of the summaries that I have of comparison of the procedures. First of all, estimated costs are one of the comparisons, and these are the current costs. In 60 days, the Patent Office is reducing them 15 to 25% for the fees. The total costs are not going to change very much because the bulk of the costs are typically litigation-type expenses. Ex parte reexamination is $20,000 to $60,000, which is comparable to what one can get into in the original prosecution sometimes. The post-grant reviews are up in the order of $500,000, certainly much more expensive than one's used to seeing in the Patent Office. On the other hand, if you view these procedures as alternatives to litigation, which in fact they are, simply because by using them you're precluding yourself from being involved in a validity challenge during the litigation. So you're selecting the Patent Office as your validity forum rather than the district court. They're at least an order of magnitude cheaper than the $5 to $15 million that we tend to think of for a full litigation. And even declaratory judgment suits can get into those kinds of ranges. Let's see, I think the last slide is basically a comparison similar to the one that Mr. Daniels showed you, but with some slightly different criteria. Bases on which to select between the various procedures. And I think I probably am running out of time, so I will, to the extent one would like to do this, if you come up after the program, I'll be happy to send you a copy of the slides, and you can look through and contemplate this a little more with a little more time.